Have you ever sent a formal letter to resolve a conflict, wondering what would happen next, feeling a mix of anticipation and uncertainty? After sending a demand letter, the ball is now in the recipient's court, and the typical next steps involve waiting for a response, evaluating their position, and preparing for potential further negotiations or actions. A demand letter, often referred to as a cease and desist letter in intellectual property disputes, is primarily a formal communication to assert your rights and invite an out-of-court resolution. It signals that you are serious about protecting your interests and provides an opportunity for the other party to understand your claims and respond without immediate litigation. This initial outreach aims to open a dialogue and resolve the issue efficiently, potentially saving both sides significant time and resources. The most common outcomes include the recipient complying with your demands, responding with a counteroffer or denial, or unfortunately, ignoring your letter entirely. If they comply, you would typically formalize the agreement with a settlement agreement detailing the terms. If they respond with a denial or a counteroffer, you will need to evaluate their position, assess the strength of their arguments, and decide whether to negotiate further, perhaps through mediation, or proceed with more formal legal steps. In situations where the letter is ignored, you would then weigh the costs and benefits of escalating the dispute, which might include filing a lawsuit. Effective follow-up and strategic decision-making are critical at this stage. Document all communications carefully, noting dates, times, and content of any replies, as this paper trail can be invaluable if the dispute proceeds to litigation or if you need to enforce a settlement. Understanding the difference between compliance and a willingness to negotiate is key to steering the process toward a favorable outcome, whether that means securing a licensing agreement or protecting your brand from infringement. Being well prepared for these various post-demand letter scenarios allows you to maintain control over the dispute resolution process, strategically respond to each development, and ultimately work towards the most effective protection of your intellectual property without unnecessary delays or expenses.